Good morning students. Today we are going to learn about the state government legislature. The structure of the state government as formed in the center. There are three wings. First one is executive, second one is legislature and third one is judiciary. Now today we are going to learn about legislature and judiciary. The legislature consists of two houses. First one is legislative council and second one is legislative assembly. And judiciary consists of high court, district court and other courts. First we have to learn about legislative council.
First, we have to learn about the Legislative Council. The Legislative Council is the upper house of state legislature. The Legislative Council forms a part of the state legislatures of India. In 6 of India's 28 states and Legislative Council serves as the indirectly elected upper house of a bicameral legislature. It is also a permanent house because it cannot be dissolved. Every member of Legislative Council serves for a 6-year term with terms staggered that the terms of 1/3 of members expire every 2 years. MLC must be the citizen of India not under 35 years of age, mentally sound, and his name should be in the voters list of the state from which he or she contesting the election. Next one is elections to Legislative Council. 1/3 of the members are elected by local bodies. 1/12 of the members are elected by graduates of the universities in the state. 1/12 of the members are elected by graduate teachers. 1/3 of the members are elected by the members of Legislative Assembly. 1/6 is nominated by the governor, who is eminent in the field of literary excellence, art, social service and cooperation. Next one is the chairman. The chairman is the presiding officer of the upper house. The members elect a chairman and a deputy chairman from among themselves. In the absence of the chairman, the deputy chairman officiate the functions of the Legislative Council. Abolition of creation of Legislative Council. Article 169 deals with the creation or abolition of Legislative Council in a state. Article 169 holds that if the state Legislative Assembly passes a resolution by a majority of not less than 2/3 of the members present and voting and by the majority of total strength of the house, requesting the parliament to create or abolish the state legislative council, then the parliament may by law provide for the abolition and creation of the legislative council. Next one, functions of legislature. Legislative powers. The state legislature can pass laws on all subjects mentioned in the state list as per the constitution. It can also pass laws on concurrent subjects. The state made law in a concurrent subject will become incorporate when the center also passes a law on the same subject. The passing of bill into law follows the same procedure as in the Union Parliament. Every bill passes through 3 readings. Then it becomes an act with a government assent. Next one is financial powers. The legislature controls the finance of the state. The lower house enjoys greater power than the upper house in money matters. Money bill can be introduced only in the lower house or the assembly. No new tax can be levied without the sanction and permission of the assembly. Controls over the executive. The council of ministers is responsible to the assembly. The ministers have to answer questions asked by the members of the legislature. They can be removed from office if the assembly passes a vote of no confidence motion against the ministry. Next one, Judiciary of the states. High Court. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. In course of time, each province in British India came to have its own High Court. After 1950, a High Court existing in a province became a High Court for the corresponding state. The High Courts are the highest courts at the state level. High Courts of India. The Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for 2 or more states or for 2 or more states in the Union Territory. For example, the states of Punjab and Haryana and the Union Territory of Chandigarh have common High Court situated at Chandigarh. The High Court and Guwahati is common for 4 northeastern states of Assam, Nagaland, Mizoram and Arunachal Pradesh. The High Court of Guwahati has its benches in Itanagar, Kohima and Aizawl. Delhi, though not a state, has its own separate High Court. Every High Court has a Chief Justice and a number of judges. The number of judges varies from state to state. The number of judges of each High Court is determined by the President. At present, there are 25 High Courts for 28 states, including Andhra Pradesh High Court, established in 1st January 2019 at principal seat of in Amaravati, and 9 union territories. Jurisdiction and powers of High Court. In their judicial capacity, the High Court of the Presidency towns Bombay, Calcutta and Madras have both original and appellate jurisdiction, while other High Courts have mostly appellate jurisdiction. Only in matters of admiralty, probate and matrimonial and contempt of court they have original jurisdiction. The Presidency High Court have original jurisdiction in which the amount involved is more than 2,000, and in criminal cases which are committed to them by the Presidency magistrates, original jurisdiction. Next one is appellate jurisdiction. As a court of appeal, all High Courts entertain appeals in civil and criminal cases from their subordinate court as well as on their own. They have, however, no jurisdiction over tribunals established under the laws relating to the armed forces of the country. Next one is supervisory jurisdiction. High Court has the power to superintendence over all courts and tribunals functioning in its territorial jurisdiction except military courts or tribunals. Thus, it may call for return for them, make and issue general rules and prescribed forms for regulating the practice and proceedings of them, prescribed forms in which books, entires, and account ought to be kept by them, and settle the fees payable to the sheriffs, clerks, officers, and legal practitioners of them. Court of Record. All the decisions and decrees issued by the High Court are printed and are kept as a record for future references by the court as well as by the lawyers, if such need arises. Thus, it is also as Court of Records. Thank you, students.